Thank you for coming back to the conference for Session 5. Session 5, which is the last session of our two-day-long conference, is titled Peaceful Settlement of Marine Environmental Disputes. Our moderator for Session 5 is Professor Lee Jae-gon. He is Professor of International Law at Chungnam National University Law School. He's here with us at the venue, and he's already on stage at his designated seat. So before I pass over this microphone to our moderator, can I invite you to give him a big round of applause?
Hello, colleagues and friends from the different time zones. As it is evening in Korea, I would have to greet you with good evening. There is an old saying that all good things come to an end. And now we are reaching a final session of the conference. My name is Lee Jae-gon. I'm a professor of Chungnam National University Law School. It is my great honor to be a moderator of this session. My special thanks go to the organizer of the conference, Korean Society of International Law, Korean Ministry of Foreign Affairs, and International Tribunal for the Law of the Sea. In this session, we will discuss the issue of peaceful settlement of marine environmental disputes. Yesterday, Judge Beck and Professor Young also addressed this issue partly. But in this session, panel members will concentrate on the issue. I am very pleased with having towering figures in the topic area. Each speaker has 20 minutes and each discussant 10 minutes. Now we will start this session with first presentation. Let me introduce the first speaker. Our first speaker is Judge Tomas Heidar. Judge Heidar joined the International Tribunal for the Law of the Sea in 2014 after a long diplomatic and academic career, and now he is the Vice President of the Court. Judge Heidar will talk about the contribution of the International Tribunal for the Law of the Sea to the protection of the marine environment. Judge Heidar, are you there?
Yes.
You have the floor.
Thank you very much. Thank you. Good morning, good afternoon, good evening, wherever you are. I'm very happy to join this 5th International Conference on the Law of the Sea, the ICLS 2020, and to also be part of this very impressive panel. Now, in its soon 25 years history, the International Tribunal for the Law of the Sea has dealt with a number of environmental cases. This has primarily occurred in the context of proceedings relating to the prescription of provisional measures under Article 290 of the Law of the Sea Convention, and also in advisory proceedings. According to paragraph 1 of Article 290, any party to a dispute on the merits before a court or tribunal may request the prescription of provisional measures to preserve the respective rights of the parties to the dispute or to prevent serious harm to the marine environment, pending the final decision. Thus, the prevention of serious harm to the marine environment constitutes one of two justifications for the prescription of provisional measures. Hence, recognizing the need to preserve the common interests of the community of states. The provisional measures phase of the MV Louisa case dealt with by the tribunal and of the Ghana Cote d'Ivoire case dealt with by an ICLS special chamber, both related partly to environmental issues. According to paragraph 5 of Article 290, that is the other situation, the tribunal has compulsory competence to prescribe provisional measures on the same grounds that I mentioned before, pending the constitution of an arbitral tribunal, which will then deal with the dispute on the merits. In the first 4 disputes submitted to the tribunal on this basis, on the basis of Article 290, paragraph 5, that is the 2 Southern Bluefin tuna cases, the Mox plant case, and the land reclamation case, environmental questions were at the center of the dispute. The marine environment also played a big role both in the 2011 advisory opinion of the ICLS Seabed Disputes Chamber on responsibilities and obligations of states with respect to activities in the area, and in the 2014 advisory opinion of the full tribunal on the request submitted by the Sub-Regional Fisheries Commission. It should also be noted as, by way of introduction, that among the 4 specialized chambers the tribunal has established is the Chamber for Marine Environment Disputes. The tribunal has thus taken cognizance of the special role it is expected to play in the implementation of the Convention's provisions on the protection of the marine environment. Part 12 of the Convention is entitled Protection and Preservation of the Marine Environment. Section 1 of Part 12 includes several quasi-constitutional principles on environmental protection, or at least notions thereof, which are then substantiated in the following sections with regard to individual sources of pollution. It should be noted, however, that beyond Part 12, many other provisions of the Convention, in other parts of the Convention, are dedicated to the protection of the marine environment. The most general principle is codified in Article 192 of the Convention, which provides that states have the obligation to protect and preserve the marine environment. This obligation is balanced in Article 193 with the sovereign right of states to exploit their natural resources. Article 194 is based on the principle of prevention. Article 195 codifies the principle of origin. Although Part 12 does not contain any explicit reference to the precautionary approach or principle, this notion is definitely reflected in the Convention, for example, in Article 206 on environmental impact assessment. However, it must be kept in mind that Part 12 of the Convention is a product of the 1970s, and its provisions therefore reflect the state of international environmental law at that time. Furthermore, the principles contained in Part 12 are, due to their abstract nature, in need for further development in order to be suitable for effective implementation. Therefore, the jurisprudence of the tribunal in this field has the potential to be quite relevant. Now, what has been the reaction of the tribunal in the last 25 years or so? It has been opined that ICLS has reaffirmed and developed the basic principles relating to the protection of the marine environment, including the precautionary approach, the duty to cooperate, the duty to conduct environmental impact assessment, and the duty of due diligence, thereby contributing to the development of international environmental law. As one scholar put it, having reviewed the jurisprudence of the tribunal in environmental matters, the tribunal has demonstrated its willingness to interpret and apply Part 12 of the Convention consistently with the contemporary state of international environmental law. This reflects the notion that the Law of the Sea Convention is a living instrument which must adapt to new developments. Another scholar has stated that the tribunal's jurisprudence in this field has been based on an integrated approach rather than a zonal and treaty-specific approach. Turning now to the Tribunal's jurisprudence, the first point to make is that it has taken a broad view of what is meant by the marine environment. Although Part 12 focuses on marine pollution, it is clear from Section 1 as a whole that it was never intended to be limited to pollution alone, and that it encompasses protection of ecosystems and conservation of depleted and endangered species of marine life. In fact, it has been argued that Article 194, Paragraph 5 of the Convention extends the scope of the principles and standards contained in Part 12 to other parts of the Convention, in particular those addressing the conservation and management of living marine resources. The southern bluefin tuna cases, of course, related to fisheries disputes under Part 7 of the Convention, rather than Part 12, but the Tribunal expressly stated in that case that the conservation of the living resources of the sea is an element in the protection and preservation of the marine environment. In its 2014 advisory opinion, the Tribunal had to, inter alia, provide a legal basis for the due diligence obligation of the flag state to take measures to prevent vessels flying its flag from engaging in IUU fishing in the exclusive economic zones of other states. Faced with the fact that the Convention does not include any provisions that refer explicitly to flag state obligations with respect to IUU fishing, the Tribunal found support, inter alia, in Articles 192 and 193 of the Convention. The Tribunal stated, Article 192 of the Convention imposes on all states parties an obligation to protect and preserve the marine environment. Article 193 of the Convention provides that states have the sovereign right to exploit their natural resources pursuant to their environmental policies and in accordance with their duty to protect and preserve the marine environment. The Tribunal then referred to the aforementioned dictum from the southern bluefin tuna cases and concluded, as Article 192 applies to all maritime areas, including those encompassed by exclusive economic zones, the flag state is under an obligation to ensure compliance by vessels flying its flag with the relevant conservation measures concerning living resources enacted by the coastal state for its exclusive economic zone, because, as concluded by the Tribunal, they constitute an integral element in the protection and preservation of the marine environment. Although the order in the southern bluefin tuna cases avoids using the term precautionary approach, the Tribunal's references to scientific uncertainty focus directly on the core elements of the precautionary approach, as set out in Principle 15 of the Rio Declaration. The Tribunal stated that the parties should, in the circumstances, act with prudence and caution to ensure that effective conservation measures are taken to prevent serious harm to the stock of southern bluefin tuna. This may be seen as an application of the precautionary approach, and this is supported inter alia by several separate opinions in the case. In the later Mox Plant and land reclamation cases, the Tribunal also referred to the notion of prudence and caution to support the view that it was urgent that parties conform to the principle of cooperation. The Tribunal in the Emile Louisa Provisional Measures case and the Special Chamber in the Ghana Cote d'Ivoire Provisional Measures case followed the same approach. In its 2011 advisory opinion, the Seabed Disputes Chamber took a step forward. It stated that the provisions of the nodules and sulfides regulations transform the non-binding statements of the precautionary approach in the Rio Declaration into a binding obligation. The implementation of the precautionary approach as defined in these regulations is one of the obligations of sponsoring states. The Seabed Disputes Chamber then continued, stating that the precautionary approach is also an integral part of the general obligation of due diligence of sponsoring states, which is applicable even outside the scope of the regulations. This due diligence obligation of the sponsoring states requires them to take all appropriate measures to prevent damage that might result from the activities of contractors that they sponsor. The Chamber finally observed that the precautionary approach has been incorporated into a growing number of international treaties and other instruments, many of which reflect the formulation of Principle 15 of the Rio Declaration. In the view of the Chamber, this has initiated a trend towards making this approach part of customary international law. Now, about a decade later, it is still not abundantly clear whether the precautionary approach is a rule of customary international law. Some scholars argue that it lacks the normative character required to constitute a rule of law. However, even if simply regarded as a general principle, the precautionary approach can be quite effective. General principles do not have to create rules of customary law in order to have legal effect. The notion of environmental impact assessments was included in the southern bluefin tuna, mox plant, and land reclamation provisional measures cases. It has been commented that the two last mentioned orders appear to show that provisional measures can be used as a judicial tool to enforce the obligation to carry out joint monitoring and environmental impact assessment, which are a prerequisite to protect the marine environment. Similarly, it has been suggested that a provisional measures application may be the best remedy available to a potentially affected state seeking to enforce Article 206 of the Convention on EIAs. However, the principle of EIAs was most significantly addressed in the 2011 advisory opinion of the Seabed Disputes Chamber, which held it should be stressed that the obligation to conduct an environmental impact assessment is a direct obligation under the Convention and a general obligation under customary international law. The Chamber then went on to consider whether the customary nature of this obligation permits to regard it applicable with respect to activities in the area also beyond the scope of specific regulations that provide for it. And the Chamber's answer was in the affirmative. The Tribunal has furthermore substantiated the general norms concerning the protection of the marine environment laid down in Part 12 of the Convention by construing from them a duty to cooperate. In the Mox Plant case and later in the land reclamation case, the 2014 advisory opinion, and the Ghana Cote d'Ivoire provisional measures case, it was stated that the duty to cooperate is a fundamental principle in the prevention of pollution of the marine environment under Part 12 of the Convention and general international law, and that rights arise therefrom which the Tribunal may consider appropriate to preserve under Article 290 of the Convention. In the Mox Plant and land reclamation cases, the parties were ordered to improve their cooperation and to consult, exchange information, monitor or assess the risks and effects of their activities, and devise measures to prevent pollution. Similarly, in the southern bluefin tuna cases, the Tribunal emphasized the need for greater cooperation to ensure conservation and optimum utilization, and it ordered the parties to resume negotiations for that purpose without delay. It is worth noting that in the first two mentioned cases, the cooperation orders were made notwithstanding findings that the evidence did not show that irreparable harm was either imminent or likely. As has been pointed out in the orders adopted in the aforementioned provisional measures cases, the Tribunal has set in motion an innovative jurisprudential trend Taking as a basis the duty to cooperate, the tribunal, through its orders, aims at bringing the parties to conduct jointly activities that may permit them to settle the dispute. It has been stated that cooperation in the control of environmental risks is one of the central elements of general international law on environmental protection. It is clear from the tribunal's jurisprudence that it regards the duty to cooperate, as far as its legal basis is concerned, as being conceptually linked to the precautionary approach. In the Ghana-Cote d'Ivoire provisional measures case, the Special Chamber addressed inter alia the obligation to protect the marine environment in relation to the exploitation of a non-living resource, that is oil. Cote d'Ivoire requested the Chamber to order that all exploration and exploitation activities conducted by Ghana in the disputed area between the parties be suspended. The Chamber took the view that the suspension of ongoing activities conducted by Ghana, where drilling had already taken place, would entail the risk of considerable financial loss, both to Ghana and its concessionaires, and could also pose a serious danger to the marine environment, resulting in particular from the deterioration of equipment. Therefore, the Special Chamber confined itself to order Ghana to ensure that no new drilling by Ghana or under its control take place in the disputed area. Finally, let me make just a few concluding remarks. First, I believe that the overwhelming response to the tribunal's environmental jurisprudence has been positive. Second, it is clear from the tribunal's jurisprudence that it has paid great attention to the procedural obligations of parties and taken the view that rights arising therefrom could and should be protected. Such rights are particularly important in environmental cases where, for example, the lack of cooperation between parties may have a serious impact on the substantive rights at stake. Third, provisional measures proceedings under Article 290 of the Convention may be particularly useful in the context of environmental cases where there is a need to act promptly to avoid further deterioration of the marine environment, for example, marine pollution or depletion of a fish stock. It should be highlighted that the relevant ground for prescribing such provisional measures, that is, to prevent serious harm to the marine environment, does not require the risk of irreparable harm. This should make provisional measures under Article 290 particularly attractive in environmental cases. And fourth and finally, tribunal may play a role in various future marine environmental challenges. I think a lot can be said about that, so I think I should stop here and maybe we can have some discussion about the possible future tasks of the tribunal in the discussions later. Thank you very much for your attention.